Welcome. It's One-Timers, and today we're going to cover professional responsibility and go over the outline with that. As of November of 2018, the California rules of professional responsibility have significantly changed. I believe that the California legislature changed about 96 rules. Before you get all anxious about it, they actually are starting to emulate the ABA more, so the California distinctions have become a lot less. The first section we're going to do on professional responsibility actually includes the most amount of California distinctions you're going to see, and it's also the most important section in professional responsibility essays. It's what these issues will show up nonstop. So part one, that has to do with the client-lawyer relationship, is the most important subject topic of PR, and that is where I would suggest you focus the majority of your time, which you're going to, because a majority of the subject is encompassed by that section. If you look at the PR outline on what to expect on your bar with professional responsibility, just like a little preface before we go into the substantive stuff, professional responsibility questions are very commonly tested. It's not tested on every bar. As you can see, 2015 February it wasn't tested. It also wasn't tested one time in 2007 and back in 2000 and 2001. But generally you're going to see PR on the exam, whether there's a crossover with a different subject. It can cross over with almost any subject. It tends to cross over a lot with business associations, and it sometimes stands alone itself, and sometimes it's tested twice on the same bar. So PR is definitely the most important essay subject on the bar. So if you're taking the attorney's exam, this is likely where you're going to start because you're almost guaranteed to get it, and it encompasses a large percentage of your exam, not the general exam. Okay, as you will know, like conflicts of interest, the duty of confidentiality, competence, the reasonableness of a lawyer's fee, and I'm reading the list of the most heavily tested issues right now, so if you can take a look at those. So you have an idea of what is likely to be tested on your exam. In fact, conflicts of interest have shown up on almost every single PR exam in one form or the other. So expect to see conflicts of interest. We'll get into that in section 1C. Okay, so now let's start off with section 1A that deals with the client-lawyer relationship, and this deals with how you treat the client. And it's by far the most heavily tested section. All right, the first topic we're going to do is the duty of competence. Very heavily tested. So the duty of competence requires, any type of representation requires competent representation. Well, what does that mean? Think about it. Competent just means you're up to snuff. You're making sure that the client doesn't have any claim for legal malpractice. So what does that take? Well, you have to have the knowledge, the skill, the thoroughness, and the preparation necessary for it. I mean, if you don't know what you're doing, you don't have the knowledge. Same thing with skill. I mean, those words are kind of used interchangeably. And if you haven't prepared for your client's case, well, then you're not really confident. You're likely to get a suit for malpractice. Okay. The way that the examiners love testing the duty of competence, by the way, into factors that determine whether or not a lawyer is competent, well, let's look at it. Well, how much did you prepare for the case? What is your experience in this matter? I mean, you're a seasoned criminal defense attorney who can easily take on a case without much preparation. If you associate it with another lawyer of established competence, what's the complexity of the matter? So these are all, you have to be probably more prepared for if you're talking about a toxic tort type of case, which is very complex. You're going to have a higher level of skill and experience and competence required for that than you would do for maybe a DUI case in criminal law, which would probably be on the lower end of the competency level. So it all determines, those are all the factors that determine whether the lawyer is competent. Now, the way that the examiners love to test this is where a lawyer practices in one area of law. So, example, they're a tax attorney, they do estates and taxes, and now they're called upon to do a criminal case. Well, they've never done a criminal case. Can they do that case? And the answer is astoundingly yes, as long as they become competent. So what would that take to become competent? Well, there's many ways that you can become competent. You look things up, you associate with another attorney, you prepare, you study. I mean, that's just the basic things to do. And remember, the California Bar exam is testing minimum legal competence. So what are you doing to become competent for this exam? You're studying, you're associating with the bar review course. What's your experience with the law school, like your intelligence level? All those are just factors for the duty of competence. So for the bar exam purposes, you want to write down the duty of competence requires the knowledge, the skill, the thoroughness, and preparation necessary to represent a client. There's different factors that go into what it takes to become competent, and if a lawyer practices in one area, the lawyer may take on a different case. So don't forget, you can be a recently licensed attorney and take a complex case and become competent in that by preparing, studying, associating with other counsel. I mean, it happens all the time. So don't be, anybody can become competent if they do the right things. All right. Now, California has just a minor distinction for the duty of competence. And California says a lawyer must not intentionally, recklessly, or repeatedly fail to perform legal services with competence. An isolated act of negligence generally does not subject the lawyer to discipline. So California says, look, if you make one little mistake, it's fine. Just don't keep doing it and don't intentionally, sink your client's case. Okay, reasonable fees. In California, the bar exam loves testing the reasonableness of a lawyer's fees. All fees must be reasonable. Well, what does reasonable mean? Well, in the real world, reasonable means how much you can actually get from the client. That's what reasonable means. But for bar exam purposes, reasonableness is determined by the time and the labor required. Like, how long is it going to take you to do this matter? I mean, let's, again, look at the DUI case. You go in there, if your client's got a 2.3 and all the gauges were accurate, plead him guilty. It's not going to take a long time. So the fee, what's going to be the fee for a DUI is probably going to be a lot less than if you're going to have like a mass antitrust suit for like a company like Apple or something like that. So, and what can you charge in the latter situation? And again, it determines on the difficulty of the case, the skill that's needed. To be like a mass antitrust attorney, or like a mass lawsuit with for a trust attorney, it takes a lot of skill. It's gonna be really difficult. You're gonna need a lot of experience, and that's why you can charge a larger fee. And what's the fee customarily charged in the area is also something like, what do other firms charge? This firm charges $400 an hour, this one charges $500 an hour, so can you charge $450? Well, if you have the experience and so on and so forth, you can. Now, so there's just different factors that go into whether or not a fee is reasonable. And under the ABA, they prefer that fee agreements be in writing. They just prefer it. It doesn't have to be. You're not going to be sanctioned if you don't have that. However, California, you need a writing unless it's under $1,000. So for a $500 case, you don't need it. If you're dealing with a corporation, it doesn't need to be in writing. If it's an emergency, you got a client that just got arrested and now they're in jail and they call you up and they say, hey, I need you to represent me, or and you can represent them. You're not going to be able. It's not feasible to get a writing in that situation. Or if it's a regular client that you do regular sorts of legal work for that client, you got a phone call which will just do. Again, it's always preferable to put everything in writing in any case. Now, California, they don't have a reasonable fee. They have what's called an unconscionable fee. It's pretty much the exact same thing. It's just ABA calls it reasonable fees. California calls it you can't have an unconscionable fee, and that's determined at the time of making. So there was actually a fact pattern, which is a really good one that was tested, where an attorney took a 1% ownership interest in a startup company that had no cash. And if you think about it, what is 1% of a startup company with no cash worth? It's like doing pro bono work. Essentially, the lawyer's not making any money. But it turns out the lawyer did some work for the company ended up growing, and the lawyer cashed in on stock for $40,000 for about 10 hours of work. Well, is $4,000 an hour reasonable? Well, in hindsight, no, but at the time of its making, it was not unconscionable. In fact, at the time of the making, it was really unfair to the attorney because the attorney was looking at never getting paid. So the reasonableness of the fee is determined at the time of the making. So the examiners did test on that one time, and it was a really good essay, and a lot of people never saw that coming. So again, you have to kind of use your mind when thinking about how things work. And use the facts on an exam. It's so important. It's not about memorizing law, it's about how you analyze the facts and how you understand it, how it works in relationship to the legal concept being tested. Okay, so again, reasonableness of the fee, different factors. ABA prefers it in writing. California, they want it in writing. In fact, California has very strong preference for having things in writing. There's a couple exceptions if it's under 1,000. There's an emergency, corporation, or regular client. Okay. Next topic, we're going to go down to the fee splitting with an attorney. Now, this is when you share a fee with another attorney. Under the ABA, you may share a legal fee. So if I get paid $1,000 for a case, I can share that fee with another attorney, provided the attorney does a percentage of the work. So if I do 80% of the work, I can keep $800, and if he does 20% of the work, my partner gets 20%. So that's in proportion to the services that we performed. Or I can keep I can share the fee, if that other person who I'm sharing the fee with assumes joint responsibility for the representation. This way that the client can sue either one of us for malpractice. So under the ABA, you can share a fee with another attorney if the fee is in proportion to the services performed, the 80-20 split, or however you want to look, 50-50, or each lawyer assumes joint responsibility for the representation. Now, of course, the client must consent in writing, and the fee must be reasonable, but we already know that the fee must be reasonable, so that's kind of redundant. And the writing part, again, is kind of redundant because on the bar exam, if you don't know whether or not something needs to be in writing, you can always suggest to put it in writing. A lawyer should always put everything in writing, even if it doesn't have to be. I mean, covering your ass is not a bad thing on this exam. And also, as an attorney, I would highly recommend you get everything in writing. Okay, so under the ABA, you may share fees if it's in proportion to the services performed or if each lawyer assumes joint responsibility. Again, it has to be in writing and the fee must be reasonable. Now, California is a little bit different. This is probably like one of the bigger distinctions that California has. California allows two lawyers to share a fee. So essentially, you can actually pay a lawyer a pure referral fee. So if you refer me a case and I make $5,000 on the case, I can kick you back $500. That's fine. Now, if I'm going to kick you back that $500, the client must consent in writing. Again, like California is all about the writing. I must fully disclose to the client that, hey, I gave this other attorney who referred you $500, so I'm disclosing the full terms of that, and I'm explaining who the attorney is, so you have to give the name of the attorney. Like, I shared it with Joe. I gave Joe $500 for referring you, and the client must consent to that in writing, and the agreement between me and Joe must be in writing. So California, again, they're really stringent on the writing requirements. If you ever get confused on the exam, we'll probably cover this a little bit later. Two things California does that the ABA does not really do. California has incredibly a demand for putting things in writing. They have a significant demand for putting things in writing, and California always wants you to keep your mouth shut. So those two things in California, what really separates, in my opinion, California from the ABA. So to recap, California allows a lawyer to pay another lawyer a referral fee. In contrast, the ABA requires that the fee being shared be in proportion to the services performed, or each lawyer assumes joint responsibility. California does not adopt ABA's proportionability standard or the joint responsibility. Okay, now if you're dealing with a non-attorney, you may not share legal fees with a non-attorney. That's it. Under both the ABA and California, you cannot. So if my sister were to recommend somebody to me, I can't kick her back $500 if she's not an attorney. You can't do that. So you cannot share fees with a non-lawyer, period. Now, does it happen? All the time. But know the rules so you know how to break them. Okay, moving on. Payments by a third party. Accepting payments by a third party. Should you accept payments by a third party? Hey, anybody who's paying your bills, take the money. That's a given. All right. So a lawyer may accept compensation for legal services from a third party if the client gives informed consent, and of course, why would the client not give informed consent? I mean, if someone's paying my bills, go ahead. You can do it all day long. There's no interference with the lawyer's judgment. And think about that. The person paying for the representation thinks that, hey, because I'm paying, I deserve a seat at the table. I get to kind of dictate what goes on. I determine how much money is being spent on this representation. I determine whether or not the lawyer does this or that. You cannot happen. So there has to be no interference with the lawyer's professional judgment. And of course, you must protect the client's confidence. Because sometimes, like say you have a mom paying for her son for legal services for whatever. Maybe the kid got arrested, he's getting charged with the crime, and the mom pays the lawyer, and the mom wants to know what's going on. Like, what did my son tell you? The lawyer may not reveal the client's confidences. So the lawyer cannot tell the mother what the son told him in confidence. Because again, the son's the client, the mother's just the person paying for it, and the lawyer must explain to the son that I'm going to protect your confidences because you're the client. I must explain to the mother, just because you're paying doesn't mean you get to dictate what goes on, and you don't get to pry into what the private conversations that we have. So the person paying for the client's legal fees usually has interests that are different from the client, including minimizing the amount spent on their representation and in learning how the representation is progressing. But the lawyer owes the duty to the client, not to the person paying. and the person paying cannot interfere with the lawyer's professional judgment, and that's the lawyer's responsibility to explain all that. Now, of course, California, guess what? California, again, prefers that the agreement be in writing, so that's the only difference between the ABA. As you will see, California is really big on putting things in writing. It just kind of goes without saying. So even if you get confused on the exam or you get lost on what the mini distinction is, just say California wants it in writing. Okay, moving on. So that's accepting payments from a third party. Contingency fee agreements. Now, a contingency fee agreement is when your fee is determined on the outcome of the case. It's the most likely to happen in a personal injury case. So let's just say you have a poor client who comes to you and says, hey, I've been rear-ended, I got in a car accident, I've got medical bills, I got whiplash, et cetera, and they have no money to pay for. They have no money to pay for the filing fees, the expert witnesses, the lawyer's time, et cetera, et cetera. So the lawyer can have the agreement be contingent on, okay, I'm going to put up all the money and I'm going to take it out of your recovery. Now, of course, the lawyer's only going to take a case that's a contingency if they know it's a slam dunk, meaning it's going to win. Okay, so what does a contingency fee agreement require? Well, first of all, it has to be in writing. Almost goes without saying. It must state the percentage that the lawyer will receive. Well, what percentage can the lawyer take? Of course, it's whatever's reasonable. What's reasonable? Whatever you can get. Generally, I mean, this is customary in the industry. It's between 30 to 40% and what the lawyer's fee is. So that, again, that would be reasonable because it's customary. It's also, you know, the time scale or whatever, all that, you know, what similar prices are for the reasonableness of the fee. So a contingency fee agreement must state the percentage the lawyer is going to take. That has to do with the reasonableness of the fee, must be in writing, and it must state whether or not the expenses will be taken out of the recovery, what expenses will be taken out of the recovery, and whether those expenses are to be deducted before or after the fee is calculated. Well, as a lawyer, you want to take your percentage before the fees get deducted. Think about it. You're going to have fees, the filing fees, you know, the lawyer's paper costs, you know, stamps, anything that the lawyer can bill you for, they will. The client's actually paying for that. That doctor that the client sees, the lawyer's not paying for that. The client will eventually pay for that. So those are all part of the expenses. Now, a lawyer wants to get his 30 or 40% before the expenses are taken out. So let's say you get a settlement of $100,000. Well, if the lawyer's supposed to take 40% of that, if, you know, say there's $30,000 in expenses, the lawyer wants to take 40% of 100 grand rather than 40% of 70 grand. Think about it, you get 40,000 in one case, you probably get like 280,000 in the next. So the lawyer wants to make sure, so as an attorney, you want to make sure your agreement says you get your percentage before the fees are taken out. So let me write that down and I'll explain how that works. So let's just say there's $100,000 and you have, the lawyer takes 30%, let's say there's about $20,000 in fees. So the lawyer gets $70,000, subtract the 20, because that's the percentage, and then, because before the fees are taken out, then the $20,000 in fees, so the client gets $50,000. That's how that works. So of course, that agreement has to be in writing. It must state percentage the lawyer is going to take, whether or not that percentage is going to be taken out before or after the fees, and again, what expenses will be deducted. You know, the paper, you know, like printing costs, shipping costs, experts, medical doctors, chiropractors, whatever the case is. Okay, so there are certain cases where you may not enter into a contingency fee agreement. So it's a domestic relations matter. So when is a divorce? You cannot have it be contingent upon securing a divorce or contingent upon the amount of alimony somebody receives, or contingent upon the amount of property that you receive in a divorce. So if you know, my wife and I are going to get divorced, say we have $1 million worth of assets to split up. Let's say I get 500,000 of the assets. The lawyer can't say, well, I'm going to take my fee based off the percentage of the assets that I get you. That's not, you can't do that. Also, you cannot do a contingency fee agreement in a criminal case, because that means contingent upon whether or not the client's guilty or not. Because guess what's going to happen? The lawyer's going to do every unethical thing possible to make their money. And that's why you can't do it in a criminal case, and you can't do it upon securing a divorce or securing the amount of alimony or property someone's going to receive in a divorce. California's agreement is virtually the same. As you know, it just says that the percentage is negotiable, but then again, everything's negotiable, so that kind of goes without saying. and if there's any other work that the client's going to have to pay for. So the extent to what the client will be charged for work not covered in the agreement, but pretty much all the works, all the expenses and all the things that the client's going to be charged for is probably already in the agreement. So again, that seems superfluous. So what you need to know about contingency fee agreements must be in writing, percentages the lawyers are going to take, and whether or not expenses are taken out before or after the lawyer takes his cut. All right, next topic, retainers. True retainer fee. Now this has never been tested, but the new California rules make a little bit of a stink about it, so I decided to add it in. All a retainer agreement is, what a true retainer agreement is you pay the lawyer money to ensure that they're available. Mostly of the time it happens in criminal cases where you say, I need this lawyer to attend my arraignment, I need this lawyer to do X, Y, and Z, and be at these particular legal stages in the process. So in order to ensure that the lawyer will show up to court for you on that day, you pay them what's called a true retainer fee, and that's to ensure the lawyer's availability. And it's non-refundable. Of course, you must tell the client that, hey, this is non-refundable, you ain't getting your money back. So that generally happens in criminal law cases. Okay, moving on to the next topic. Duty of diligence and zeal. Well, what does diligent mean? Diligent means be prompt, be on top of things. So you must be diligent in representing a client, and you must not have any undue delay. Also, as you're being diligent while you're making sure you're taking care of your client's case promptly, you must treat others with respect. So if somebody asks for a much needed continuance or, and they have good cause for it, you can't say no, you have to play fair with others also. In terms of, so that's diligence. Diligence is promptness in representing a client. You must not act with any delay, and you must treat others with courtesy and respect. Now, in terms of the duty of zeal, zeal just means you're putting in your effort. So a lawyer must zealously represent a client and take whatever lawful and ethical measures are required to support a client's case. So you can't do anything unethically or legal or dirty, but you do have to press for every advantage, you don't have to press for every advantage you have, but you do have to do what you can to make sure your client's position is fully supported, and that's what the duty of zeal is, to take whatever lawful and ethical measures are required to support the client's claim. But again, you don't need to be difficult or unreasonable with others, and you don't have to need to press for every little advantage. Just play fair with everyone else. It's essentially what they're doing. Okay. Moving on, and the duty to communicate. Very simple. Return someone's phone calls, tell them what's going on. So a lawyer must communicate with the client and keep the client reasonably informed about all significant developments within the case. So anything that's important in the matter, you must communicate with the client. For example, you must convey all settlement offers and plea bargains. Think about it. If you were in litigation, and litigation is very costly, somebody wants to settle and get out, the lawyer must convey that to you. If you're a criminal client, and you're possibly facing jail time, if you have a plea bargain, the lawyer must convey that to you. So they must convey all settlement offers and plea bargains. So essentially, the lawyer has a duty to communicate all important matters to the client. And also, California makes a note that you have to return clients' phone calls. That's never been tested, but think about it. If the client's calling you and reaching out to you for information, you should call them back. That's part of the duty to communicate. All right, moving on. Scope of representation. And that means who makes the ultimate decision. Generally, a lawyer must abide by the client's decision concerning the scope of representation. In a civil case, that means the client decides whether or not to accept a settlement, what plea to enter in a criminal case, whether or not to have a jury trial in both criminal and civil. Of course, you should consult with the client and say, hey, this is why I recommend we have a bench trial or a jury trial, but ultimately the client decides. And the client also decides whether or not to testify. Now, lawyers often will counsel their clients and advise them whether or not to testify, especially in a criminal case where you have a client who has a lengthy criminal record, which is called a rap sheet, and because that's now going to be exposed on cross-examination through impeachment, prior convictions. You might remember that as a way to impeach somebody. So the lawyer might just, say, hey, I don't think you should testify, but again, the lawyer decides what settlement to accept, what plea to make, whether to have a jury trial, and whether or not to testify. So what's the lawyer's responsibilities? The lawyer deals with all the procedural aspects of it, like what objections to make, what evidence to introduce, what motions to file, I mean, God, half of you don't even know all the evidence rules and what objections to make. And when you're, how could a client possibly know what the objections to make? That's the lawyer's responsibility. And motions to file, whether it's a motion to suppress, motion to quash, motion for summary judgment. The client's not gonna know that. That's why the lawyer makes those decisions. And what evidence to introduce, client's gonna have no idea. That's the lawyer's responsibility. So the lawyer deals with all the procedural decisions, whereas the client makes all the substantive decisions. Okay. And finally, part of section 1A is counseling the client to break the law. Well, you can't do that. So a lawyer must not tell a client or engage, counsel a client to engage in conduct that the lawyer knows is criminal. So you don't encourage the client to commit a crime, simple as that. Also, you can't tell the client, you can't instruct the client on how to break the law and get away with it. I mean, as lawyers, you gotta understand how certain things work and how, how do I put this in delicate terms? Anyways, you just can't, you can't instruct the client on how to break the law and get away with it. However, what you can do is make a good faith effort to test the validity of the law. And this happens a lot in constitutional law. Let's say that there's a statute on the books that looks to be vague or overbroad or maybe discriminatory or violation of equal protection. Well, in order to have standing to be able to contest that particular law, you have to break it or else you won't have standing. So you can say, look, I'm going to explain to you how we're going to be able to test the validity of this law, and you might have to engage in conduct. So the lawyer may suggest that a client violate the law for the purpose of challenging the constitutionality of that law. Otherwise, they wouldn't have standing to sue. But generally, you can't just counsel a client, hey, don't encourage the client to break the law. That's all that's all it is. So what they mainly test on in this is the good faith effort to test the validity of the law. And you're allowed to do that as an attorney. Okay, and that's a wrap for section 1A that deals with just clients. Again, the most heavily tested section, and the one with the most California distinctions as well.